Welcome back to the Dean Obeidallah Show. Right now, very happy to have back on our friend Glenn Kirschner, former 30-year prosecutor, served in the U.S. Army in the JAG Corps. You see him as a legal analyst on NBC, MSNBC, and his YouTube channel is wildly popular. Justice Matters with Glenn Kirschner. Hello, Glenn. How are you?
I'm well, Dean. How are you?
Good. You know, there's a lot of law stuff, although it might slow down a little bit in the summer now because of just things getting adjourned. But, you know, I wanted to talk to you first, and I had that Danny Savalas character on last week, but let's have a prosecutor with some insight to the right things here. I want to get your reaction to this SCOTUS immunity decision, and that, you know, they broke this down: absolute immunity for constitutional obligations and power things. Official acts, you get immunity that's rebuttable presumption, but it seems like it's really going to be hard to overcome. And then the third are unofficial acts, whichever they decide, because the Supreme Court's ultimately going to decide what you can do and what you can't do. It's kind of remarkable. So what's your reaction to this?
You know, it's a president is king. I wouldn't even say it's president is king -1. It's just kind of president is king. They continue to march us toward becoming a banana republic. Why? I guess ultimately they want all the power. They want all the money. They want to make sure they can enrich themselves and retain their power at all costs. And they've given Donald Trump the opportunity to do that. And, you know, it is no small thing that they say things like, okay, for core constitutional powers, a president is not only absolutely immune, but you can't even look behind how he exercised the powers. So let's be clear. That is the Supreme Court saying Donald Trump could set up a pardon kiosk in the lobby of the White House and sell pardons for $1 million a pop. And no law enforcement agent, no prosecutor, and no court can even ask why he did it, how he did it, or what his motive was. He gets to pocket the money. They also said a core constitutional function is talking with his attorney general and telling his attorney general who to prosecute. And you can't look behind it. So Donald Trump could say, hey, Mr. AG, I don't know if next time around in the horrific event Donald Trump becomes president again, and he won't, if he'll appoint Bill Barr, or if he can find somebody more corrupt. I would be surprised if he could find somebody more willing to do his criminal bidding than Bill Barr. So maybe he just puts Bill Barr back in place. He says, hey, Bill, round up my enemies, detain them without charges, without indictments, without any due process. And I get to do it because the Supreme Court says I get to do it with immunity. And I also get to pardon you in the event you committed any crimes in carrying out my unlawful commands. We're all good. I mean, this is exactly the blueprint that the Supreme Court handed all presidents. You know, one of the questions I've asked, and I think we have to ask it, is should Joe Biden do anything with this newly obtained power of lawlessness that he has? You know, this is really the Supreme Court sort of putting its stamp of approval on Richard Nixon's claim that if the president does it, it's not illegal. It couldn't be more dangerous. It couldn't be more antithetical to the founding fathers' view and hope for our country, or why, you know, we decided to break off in the first place. You know, we were fleeing a monarchy. And yet here we are. And everything the Supreme Court has been doing in recent months, years, has been moving us in this direction. Why? I don't know. I wish I knew why, other than they just want all the power and money for themselves.
And let, you know, Trump and other Republicans make the money too. So just so it's clear for people, for example, appointing judges is a power given only to the president in the Constitution. He can literally list judgeships on eBay, right? And people can bid. And he's like, oh, he won. So we're going to give him, and they can't prosecute Donald Trump. They can't investigate Donald Trump. The Supreme Court has said that's legal now for the president. Absolutely.
Yeah, it is. They put fancy words to it, and they think it's going to persuade people, or at least fool them, that if it's the president's exclusive and preclusive power, he can do whatever he wants. It can violate all of our nation's laws. He can hurt people, victimize people, and it just doesn't matter. We saw Donald Trump already flexing his absolute presidential immunity muscle by calling for a military tribunal prosecution of Liz Cheney. I assume that as commander-in-chief, that is his what? Exclusive and preclusive responsibility. So he can call for, and the thing about military tribunals, I was an active duty Army JAG for 6.5 years, Dean. is they are run outside the criminal justice system. They're beyond the reach of federal judges. So it would literally be Donald Trump as judge, jury, and executioner. And apparently he gets absolute immunity in that arena too. So does that mean Joe Biden can start to order military tribunals for people who are actually the enemies of our democracy? The answer to that question is yes. He's been given permission by the Supreme Court to do it. Will he do it? Think about this. Donald Trump will simply say, I designate all of my perceived enemies as domestic terrorists, danger to our democracy, and enemy combatants. Round them up. Military tribunals for all. He gets to do it because the Supreme Court said he gets to do it. Can Joe Biden turn around and say, I actually am designating people who tried to destroy our democracy on and around January 6th as the enemies of democracy, as enemy combatants. And so I guess we should run some military tribunals for those people. Heck, some of them have already been charged with crimes. Many of them will be charged in the near future. I believe more federal indictments are coming shortly, and we can talk about why I believe that. But should Joe Biden, should he exercise that power, Dean? I'm a rule of law guy, and I have been all my life. Not a political guy, never have been. It makes me uncomfortable saying when the Supreme Court says the lawless is now lawful, for me to say, let's do it, because it still feels lawless to me. Right. But if the Supreme Court said it's not, I guess it's not.
So Joe Biden could go tell his DOJ to prosecute Clarence Thomas right now for the clear bribes that were involved, right? There's no problem with that. He could say, Merrick Garland, I want you to investigate and prosecute Clarence Thomas. Fine.
Yes. President Biden would have absolute presidential immunity for that act under the Supreme Court ruling.
I'm chatting with a friend, Glenn Kirschner. Glenn,
and mind you, Dean, I'm not saying he should go out and do that, because every time I raise these issues, little fringe media outlets, right? Oh my God, let me tell you. Well, I'm not saying, I think we have to have this discussion because the Supreme Court has just granted all presidents this power.
Right. Donald Trump as president was very upset with Saturday Night Live for mocking him and for late night hosts for mocking him. So now he's absolutely immune if he won and they were doing sketches about him. And he goes, I want you to investigate Lorne Michaels from Saturday Night Live. I want you to investigate the actor playing me. I want you to investigate the television show. Like Richard Nixon was upset with the Smothers Brothers. He can actually, and now in paper, he's been told he can do this. And I think people should understand Donald Trump will do this. Like there's no limit. The guy put it in writing. He wanted the FCC to investigate Saturday Night Live when he was president for mocking him. He will direct them to investigate and to find some crime. They can find something, I'm sure, of someone on that show as a deterrent, put a chilling effect so others don't mock him. I would imagine we might see this.
And the folly of the Supreme Court opinion, I urge everybody to read it. The whole thing, all 119 pages. I mean, the majority opinion is important because that's where all the bad unconstitutional stuff is going on. The dissent of Sotomayor is equally important because she highlights all the bad and unconstitutional stuff and dangerous stuff that's going on here. But the folly of it, Dean, when we're talking about what you just described, Donald Trump telling his attorney general to go out, investigate, and prosecute people, right? The Supreme Court opinion says, well, that's because Donald Trump and any president has the constitutional obligation to take care that the laws of the nation be faithfully executed. Therefore, he gets to violate the laws of the nation with impunity and immunity. I don't know. I'm not a logic expert, but there seems to be a disconnect there. In other words, they're saying anything the president does enjoys this immunity because it is presumed he will be doing it, in furtherance of faithfully executing the laws of the nation. But we all know Donald Trump is indicted for doing things that are contrary to faithfully executing the laws of the nation. So the Supreme Court's own opinion falls under the weight of its own frivolity and illogic. But we're all just like, oh, and I guess chocolate rations are up too after the government cuts our chocolate rations a la 1984 in Orwellian fashion. I guess we're just supposed to enjoy the chocolate rations we're told we have, but that we don't really have.
Well, I think that it says a lot that this is not a decision written in the 1950s before any of these things happened. They saw Donald Trump They know he's being convicted of crimes. They know he attempted a coup. They know he incited an attack. And now they're protecting Donald Trump if he wins again, or another Republican president, or dare I say, a Democratic demagogue one day, which could, I always warn people on the right. You're telling me there won't be a Democratic demagogue one day who comes in and says, I'm doing this for the good of the people and sincerely believing it, and I got to put my political opponents in jail. Well, now that person is protected. Thank you, right wing Supreme Court. It's stunning to see this. How does this affect the Justice Roberts, Chief Justice, all concerned about the credibility of the court? Isn't this done? Is there no? It's to me, it's just part of the GOP. It's nothing to do with credibility anymore about
Yeah,
it as a judiciary.
they have no credibility left. I do believe this opinion, Trump versus United States, the absolute presidential immunity opinion, will absolutely go the way of Dred Scott, Korematsu, and Plessy versus Ferguson. I think it will be, we will look back on this sad, dangerous, hateful chapter in our nation's history and say, how did we end up there and how did we let it come to that? Because we've been through this before. So I do think we will rise to the occasion. The good news is, even though all of Donald Trump's criminal cases have come to a screeching halt, courtesy of the Supreme Court opinion, we, the American people, have now been selected as the final jury in Donald Trump's case. And we get to vote on November 5th. Ordinarily, what we do as jurors is we assess the evidence and we vote guilty or not guilty. But in this case, we have assessed the evidence and will continue to do so. And we will vote Donald Trump is guilty on November 5th by voting against him. We are the jurors. We are the only ones who will save us. And that was always the case, Dean. No prosecutor, no FBI agent, no judge, no politician was ever going to save us. It is always up to us. And the good news is we are the final jury.
We are the executioners of the sentence too. If we can defeat Donald Trump, that's the end of him. And I think he'll go ballistic and try another January 6th attack, but we'll see. So you mentioned the other cases are impacted by this. So there was a July 11th. We were going to have the sentencing of Donald Trump for 34 felony convictions here in New York. That's put off to September. What do you see from reading the opinion and seeing what Judge Marchand has said? What's the potential impact on the New York case?
So this is an easy call on the facts and the evidence, and I think it will be a relatively easy call for Judge Marchand. But then let's talk about what happens after Judge Marchand concludes. And this is what I think he will conclude. Nothing Donald Trump did is an official act, right? Most of what he did, most of the incriminating evidence, he committed before he was president. Can't have presidential immunity if you ain't president. He did some of it after he was sworn in, like writing reimbursement checks to continue to cover up his crime, the conspiracy that he was in with Michael Cohen. That's not official presidential conduct in anybody's view of the world. So Judge Marchand will appropriately hold an evidentiary hearing. He will make findings and he will conclude that the convictions are sound. They should not be vacated, and he will move forward to sentencing. Donald Trump will try to put a stop to it. And the greatest concern is that if Donald Trump can somehow jump into the federal system and bubble this issue up to the Supreme Court, might the Supreme Court say, well, it's an official act of a president to pick up a pen and put it on a piece of paper and sign his name. So therefore, we're going to err on the side of saying the reimbursement checks qualify as official acts for which a president has immunity. I would like to say I don't think they'll go that far, but they are no longer, fair judges of the law. They're just not. They have shown themselves to be in the tank for Donald Trump.
Is there any potential that, because yes, I agree 100% with you about the actions, the conduct of Donald Trump predates being president, and then it's a continuation of the crime as president, not an official act. But what about some of the evidence that came in? Is there any scenario from a legal point of view the judge can say, I don't think it affects, look, your actions, your conduct are all fair game for prosecution, but some of the evidence should not have been allowed in, and now we have to order a new trial?
Yeah, first, I'm not going to pretend to have complete recall of every item of evidence, every statement, every record that was introduced during the course of the trial. But let's go with your hypothetical and assume there's a smattering of evidence that could perhaps
Like Hope
enjoy
Hicks or
some
some
kind of
tweets, stuff like that. Right.
official act immunity. Okay. So the beauty of it is that in every single prosecution, including every one I did in my 30 years as a prosecutor, mistakes are made. Mistakes are made by prosecutors, defense attorneys, judges. And that is why there is a doctrine, once the case makes its way to the appeals court, called harmless error.
Mm-hmm.
You judge an error that was made in the trial court to see whether it was harmless. In other words, whether the balance of evidence is enough to support the guilty verdicts reached by the jury, or whether it was so central and so damaging and so prejudicial to the case that the case has to be vacated and remanded for a new trial. I don't believe we are anywhere near prejudicial evidence territory. If anything, we're in harmless evidence, harmless error territory. So one way or another, in an honest court of law, I think we're going to be fine.
It just could delay the sentencing and the execution of the sentencing, depending on what happens here. I imagine they'll appeal to the appellate division in New York, then they'll try to go to Court of Appeals. Then at that point, maybe they'll try to get to the U.S. Supreme Court. We'll see how it works out. I'm talking with our friend Glenn Kirschner. So, Glenn, the Georgia case is already on hold because of the question about conflict of interest by the appellate court there in Georgia. But can you see, and I'm not asking you to analyze every piece, every count against Donald Trump in the Georgia case. I think there's still 10 felony charges. But is there, from your point of view, is there anything in the immunity decision that could affect the Georgia prosecution?
It could. It could. I think the lion's share of it will not affect the Georgia prosecution because this was Donald Trump not acting as president, but acting as a candidate, somebody who desperately wanted to cling to presidential power and overturn the results of an election that he had lost. By all accounts, he had lost. So I think most of it will be deemed private conduct, candidate conduct, not official acts, therefore not, appropriately the subject of presidential immunity. There are some things that I think could be viewed as presidential acts when, he's looking into the integrity of a national election, blah, blah, blah. Oh, it's a bunch of horse shit, which that's a legal term, horse shit. But here's the good news, to the extent we can find any little bit of silver lining in any of this, because the Georgia RICO prosecution is in a pretrial status. All of this can be litigated in hearings prior to any trial commencing. So the landscape will be sorted out, and they will be able to excise out of the case anything that might cross the line from, unofficial conduct into official conduct, such that he would be immune. So I think we're going to be fine. Of course, Dean, 2, 3, 4, 5 years from now, you and I are going to be talking about these legal issues because these cases will still be percolating through the courts.
And that's fine. Trump loses. It's just the normal process of a trial. If it's 6 months from now, if it's a year from now, if it's a year and a half from now after appeals, so be it. The issue was a trial. And so in the case of the January 6th case, which is impacted by this and their January 6th decision, their decision on the obstruction of Congress case, that goes to Judge Chutkan, right? We're just waiting for essentially the file or the case to be brought back to life. And I heard it'd be 30 days from the opinion date of the Supreme Court. Does she actually have the case and then start some hearings?
She will get the case back on remand, and I think it's 30 days before the mandate issues, and that's when she gets it back. Okay. And then she will begin holding evidentiary hearings. And the good news is that will at least give the American people an opportunity to see a bunch of the evidence, not directly, because God forbid we should let people see what goes on inside federal courtrooms. We're not strong enough to handle that. What a stupid rule that is. But at least secondhand, I'm in that courthouse all the time, and there's a media room where you can actually blast out in real time exactly what's going on in the courtroom. So that's good news. I think what Judge Chutkan is going to do is hold really wide-ranging hearings on issues of, well, is something an official act or is it not? There's going to have to be lots of evidentiary development on that issue, lots of argument on that issue. And let me just add, because people might remember seeing that they can't use evidence of official acts to inform anybody about what might be an unofficial act. But you know what, Dean? That only applies, as I read the Supreme Court opinion, to a trial. You can't introduce at trial evidence of official acts to bolster evidence of unofficial acts being crimes. And we could talk about that. That's like a whole law school class right there to unravel that insane new rule of evidence and procedure that the Supreme Court made up, fabricated out of thin air is what they did. But man, they just can't quit Donald Trump, can they?
I know.
But here's the thing. So I think she's got to let the parties present all of that evidence and all of those arguments, and that will at least inform us about what kind of evidence Jack Smith has that we have yet to see. So that will be helpful as we, the jury, head into November 5th.
And that's a good point. We're going to have these hearings. We're going to learn more about the evidence against Donald Trump, his actions. It'll remind people. Most of us know what it is. People listen to my show and follow Glenn and others like that, Frank Figluzzi. You know what Trump did. We're aware of it. But it's more important that our fellow Americans know a lot more about it. So the last case, the classified document case, which Judge Cannon already was sitting at the defense table. So now she's going to have a hearing on the briefing the issue of immunity applies in the classified documents case, even though everything is after he leaves office. I mean, the entire thing is him not returning documents, nothing there, but she'll do anything she can to get on the Court of Appeals or the Supreme Court. What do you expect? Anything to happen in this case? I mean, this is just a joke. It really is laughable.
Yeah, she's brought this case from a dead stop and she's thrown it in reverse. But there are some things to really dislike about what Judge Cannon just did. First of all, there are multiple motions that Jack Smith has filed that Judge Cannon just sits on for months. Think back to May when Jack Smith filed a motion that had some urgency to it. Donald Trump is lying and endangering the lives of FBI agents. And Jack Smith filed a motion saying, Judge, please just modify the conditions of release for Donald Trump in this one very narrow way. Make him stop lying and endangering the lives of FBI agents. Because let me tell you, what he did was after the FBI coordinated with Donald Trump's lawyers before the execution of the search warrant at Mar-a-Lago to make sure that when they executed the search warrant, neither Donald Trump nor any of his family members would be in the state of Florida, right? Just to be safe. And after they executed the search warrant, and with this knowledge, Donald Trump said, they came down there to assassinate me and endanger my family.
Yep.
That endangers FBI agents. It puts a target on their backs. So Jack Smith back in May said, please, Judge, just this one thing. Can you do this one dang thing that the law, suggests you should do? She's still sitting on that motion. Dean, on Friday, Donald Trump's lawyers said, yeah, Judge, we're filing a motion. We want you to stop these proceedings and, delay all of the deadlines in this case. On Saturday, when the courts are closed, in less than 24 hours, Judge Aileen Cannon, the court jester that she is for Donald Trump, said, you got it. Let me, stop. It's all stop. Anything else, Donald? Anything else I can do for you? That's obscene, and it continues to show that her impartiality is subject to being questioned, and she ought to get the hell off the case, or Jack Smith ought to file a motion to have her removed from the case and litigated up through the 11th Circuit Court of Appeals, because her bias is just laughably, it's transparent. So here's what will happen, I predict, in the litigation on the issue of presidential immunity. Donald Trump will say, wait a minute, it is an official act for me to take all of these classified documents with me as president. And therefore, the whole prosecution must be thrown out. Why? Because no prosecution, no criminal charges based on my possession of these documents that I took in my official capacity can be pursued. You got to throw the documents out. No documents, no crime. I didn't violate our nation's espionage laws, and I didn't fail to produce documents that can't be introduced as evidence against me when the grand jury subpoenaed them. So, Judge, you got to just throw the whole case out. That's where they're going to go. Will Judge Cannon be receptive to that? What do you think?
Of course she will be. And look, this Supreme Court really in one decision, it's almost like they worked and reverse engineered it. They go, okay, how are we going to protect Donald Trump in every single case? Let's do this. This is how we can do it. And because it's remarkable. It really is such a jarring decision, not just in the conclusion, but the breadth of it and how it's designed to protect Donald Trump. I mean, it really is designed to protect Donald Trump. And from Trump, if he gets back in, give him the playbook of the criminality that he can commit openly and flaunt it. Just he can say, I just took my DOJ. We're going to prosecute all Democratic leaders in the House because I know they committed crimes, and go out and find it. But look, on a bright side, Steve Bannon is in prison right now, and it's really hot in Washington, D.C. So there was a little bit of accountability there. And I mean, what's your reaction to him finally going in, the Supreme Court not protecting him? And I guess he's never been president, so they didn't care.
Yeah, a little bit of accountability is a beautiful thing. And, listen, it is no fun serving time. I have been in more confinement facilities as a former career prosecutor, both civilian facilities and military facilities, than I can count. They're not pleasant places to be, and I don't celebrate anybody going into one of them. What I will say is that it's got to be especially hot for Steve Bannon because I assume he's wearing 3 jumpsuits. It's not going to be a fun 4 months for him, but he has so richly earned this prison term. And let's not forget, Dean, when he gets out, he gets prosecuted in New York for stealing money from Donald Trump's supporters, pretending like Steve Bannon's going to build a wall when instead he was just building his bank account. And those are crimes for which he accepted a pardon, a federal pardon. Of course, now he's being prosecuted by the New York State authorities because he also committed crimes in violation of New York State law. Boy, if I'm a prosecutor, one of the issues I'm litigating is his decision to accept a pardon, which the Supreme Court in 1915 said carries with it an imputation of guilt and is some confession of guilt when you accept it. Is that relevant to his guilty state of mind? You're darn right it is. And I hope a judge will rule that way.
I agree. And very last thing in the last minute here, not to go into too much detail, but Snyder versus United States, 6-3 Republican decision. So Kavanaugh writes the opinion. So now it's not bribery if you take a nice gift after you do the act. That's a gratuity. Like here's a $13,000 check for you, not connected to what you just did for me. This is unbelievable to see this distinction.
Dean, is there any way that the ruling class gets to enrich itself that the Supreme Court doesn't love and embrace? Snyder, in 30 words or less, is when a politician is approached and somebody says, I'd like to give you a bribe to take an official act in my favor. And the politician says, no, I couldn't. But after I do the official act, I'll take whatever you want to give me as a gratuity. That is the Snyder case. And the Supreme Court says, oh, it's not a bribe, it's a gratuity. And what could possibly be wrong with government officials taking gratuities as thanks for their official acts? It's insanity. It's the rule of law being turned on its head. We're living in the legal upside down, and we have an illegitimate radical right-wing bloc of the Supreme Court that is all in on making us a banana republic.
All Senator Menendez had to do is take the gold bullion after he did the stuff. The mistake was before, and that's the distinction. This is insane. Well, my friend Glenn, thank you so much. And if people want to see, and I really I always reshare it on Twitter, your videos. If they want to check it out, YouTube, Justice Matter with Glenn Kirschner, number 2.
Yes. Number Glenn Kirschner 2, but just go on YouTube, put my name in there and it'll pop up.
All right, Glenn, thanks so much for spending time. I really appreciate it, brother. Have a great day.
Thanks, Dean. Great talking to you.